Are you ready to start?
Good to go.
Okay. Um, we'll go on the record now. Time is just about 1 o'clock on May 7th, 2026. This is a hearing for Deschutes County file numbers 247-25000-727-PA, 247-25-000-728ZC. My name is Greg Frank, and I am the assigned hearings officer in this matter. And before we turn to the particulars of the hearing, I would like to turn things over to Mr. DiMarzo to describe how the electronic process is going to be working today. Mr. DiMarzo.
Good afternoon. Thank you, Hearings Officer Frank. The item before you today is a request for a comprehensive plan amendment to change the designation of an approximate 51.86 acre parcel from agriculture to rural residential exception area. This proposal also includes a corresponding zone change to rezone this area from exclusive farm use to multiple use agricultural. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing. This will be followed by a brief presentation on the application. The county has established time limits for testimony as follows. The applicant will be afforded 30 minutes, public agencies 10 minutes, the general public 3 minutes, and then finally rebuttal by the applicant for 10 minutes. The hearings officer can modify or eliminate these time limits as he sees fit. Then the testimony portion of the hearing will begin. First, the applicant team will present, followed by any public agencies. Next, those in support, followed by those in opposition, and finally, anybody neutral to the application will testify last. Afterwards, the applicant will be afforded an opportunity to present their rebuttal testimony, and then finally, staff can make any closing comments. Testifying at today's hearing, this is a hybrid public hearing. We accommodate both in-person and remote participation. Before starting your testimony, please provide your first and last name as well as your mailing address for the record. For our in-person participants, if you do wish to testify, please add your name to the sign-in sheet at the table up front. I will use this name to call up participants if needed for their testimony. After your name is called, please come up to the table one at a time in front of the room before your testimony. For our remote participants, which I do not believe we have any today, but if anybody does log in and wants to testify, they do need to log into Zoom or call in using the Zoom dial-in option. When Hearings Officer Frank does ask if anybody attending remotely would like to testify, they'll need to use the raised hand feature or dial *9 on their phone. In addition to oral testimony, if anybody has written testimony that they would like to submit, please hand it to me up here. For those of you in person, please submit that written testimony to me after your oral testimony. If you are participating remotely, you can submit your written testimony to me via email, dan.demarzo@deschutes.org. And finally, Hearings Officer Frank and I are responsible for conducting an orderly hearing today. Any testimony or behavior which is deemed inappropriate will be addressed and may result in that member of the public being asked to leave the hearing. Are there any objections to the format of the hearing? Seeing none, I will turn it back over to Hearings Officer Frank.
Thank you, Mr. DiMarzo. As Mr. DiMarzo described, we are following the normal hearing procedures in the county's code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. I'd ask for your patience as we make sure we get through each of the steps Mr. DiMarzo just outlined. The application's being considered through a quasi-judicial process. I will consider only the factual evidence in the record. I will then apply those facts to any relevant provisions in the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. I will then apply these, they are also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they are also available directly from the staff upon request. It is important that you direct all your testimony to the standards and the applicable criteria. If you believe a criterion does in fact apply that it was not listed, you may address the unlisted criterion. However, I strongly urge that you explain why this criterion must apply and do so with specificity so that other participants, I'm one of the participants here, so I understand and can respond to that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. I also urge you to explain Land Use Board of Appeals. Also, the failure to raise constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in the circuit court. As I just noted, I serve as county hearings officer in this matter. That's the role that I've been assigned. In that role is my job to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant in this case. To that end, I will state for the record that I do not have any relationships with the applicant, and I am not aware of any connections that I may have with participants in this proceeding that would prevent me from remaining impartial. Just as a note, just for full disclosure, my anticipation is that legal counsel for the applicant has appeared before me on numerous occasions, and I'm also being somewhat presumptuous. If there's someone here from Central Oregon Land Watch who submitted something in writing into the record, if there is a participant on behalf of Central Oregon Land Watch, those representatives have also appeared before me in prior hearings. I have communicated, with staff, but only discussed the particulars of today's hearing and not the substance of the applications. I have not had any ex parte contacts that I wish to disclose. It is my obligation to preside over this hearing in an efficient manner. Before we go any farther, I'm just going to check, Mr. DeMarzo, you can help me with this. Does anybody either present or online have any objections that I continue to act as hearings officer in this matter or challenge the county's jurisdiction in this matter? So, Mr. DeMarzo, I'll rely on you to let me know what's going on.
No objections, sir.
Okay. At this time, I'm going to ask the applicant, the staff to present the staff report. Just one question, and it's going to relate to your staff report just ever so briefly, is I have done some review of a number of the land use decisions that have been referenced in the staff report and in a supplemental submission by the applicant. There's actually quite a few cases that have been referenced. I have reviewed a number of those. If you wish to know which ones those are, then please inquire. But certainly they include the Destiny Court decision, which I was a participant in at least way back when. I have also reviewed the Jefferson County case, there's 3 or 4. So just ask me, and I'm more than happy. The other thing I took notice of, because there was reference in a number of those cases to the R1 designation and the MUA 10 designations, and then some conflicts occurring between the comprehensive plan that was in place and perhaps what is going to be in place or is now in place or in progress. So what I'd like, Mr. DeMarzo, you to answer me 2 questions. Which version of MUA 10 are we operating under? I believe that the most recent revision to the uses allowed in that in 1832.040 was 7/1/25, but I don't know if I just want to make sure I know exactly which version it is, and that in fact I have a copy of that version so that I can do that. And then I'd like, at least in your presentation, kind of a very brief summary of where we stand with what provisions of the comp plan or a comp plan are now applying. So with that, then this is time for the staff report. I kind of screwed up his presentation, but I'm more than happy to have those answers come after your staff presentation.
Sure thing. I appreciate that. As my computer loads, I'll hold off until after my presentation to address the modern day provisions of 1832 MUA 10 zone. But I believe the date you had was correct. With that, I will present a brief staff presentation. Okay. Thank you, Hearings Officer Frank. Briefly, a little bit more information on the subject proposal, which again is a comprehensive plan amendment and corresponding zone change. The property consists of two undeveloped tax lots. That combined, they encompass an area of approximately 51.86 acres. The parcels are located approximately 0.65 miles east of the City of Bend's urban growth boundary and south of Butler Market Road. The applicant has requested an amendment to the Deschutes County Comprehensive Plan designations for the property. They are requesting a change from the current designation of agriculture to rural residential exception area. The applicant has also requested a concurrent change in the zoning designation from exclusive farm use within the Tumalo-Redmond Bend subzone to multiple use agricultural. The applicant has not requested an exception to statewide planning goal 3 agricultural lands on the basis that the property does not meet the definition of agricultural land. In support of this argument, the applicant has submitted an Order 1 soil survey report prepared by Gary Kitzrow of Growing Soils Environmental Associates as part of the application. This report concluded that the property consists predominantly of capability class 7 and 8 soils. We've received one public comment by Central Oregon Landwatch, who is here to present today. This comment has been uploaded into the record. The record is current as of 1 p.m. today. However, I will note that staff received a revised supplemental material from the applicant's team. It's my understanding the applicant is expecting to explain the revision, but it's also my understanding that no substantive changes were presented. It was just formatting. And with that, I am available for any questions that the hearings officer has. And if you'll bear with me, I can get you the appropriate date of the modern day MUA 10 code. So that July 1 is the correct date, amended by ordinance 2025-009, and that is the appropriate code that applies to today's application.
And any brief comments on the status or what's applicable to this case from a comprehensive plan perspective?
So if it's okay, I think I may respond in the open record period to that, if applicable, if there is an open record period.
Okay.
At the risk of misquoting the comprehensive plan, which is currently being challenged, I'd like to just clarify some details before responding.
Absolutely. Thank you very much. This will be the time and the place for the applicant or applicant's representative. When you come up, would you please do me a favor and give your first and last name, spell them slowly, and give us your mailing address. With that, you're more than welcome to start your presentation.
Good afternoon, Hearings Officer Frank. Thank you for your time today. Chris Koback, Koback, and I'm with Buchanan Schmidt here in Bend at 937 Northwest Newport, Suite 220, 97703. With me here to my right is Cody Tuma, who is the member of Dickey Road LLC, the applicant. I'll be presenting, but I wanted you to meet the face of the applicant. I also have Greg Jacobs behind us. He'll come up later as in our presentation and talk to you a little bit about farming. He's a local farm consultant. For a procedural thing, yes, I did clean up a letter on page 2 of my letter that you have, the formatting under DCC 18136.020 was my handiwork. I'm trying to be more self-reliant, and I messed up the formatting terribly, and I had an A at the end of those quoted provisions that should have been D. And then I didn't have the 1 and 2 after subsection C. So I've cleaned that up for you and uploaded a new letter, and I've handed one to staff and to Mr. Isbell from Central Oregon Land Watch. But there were no substantive changes. I just felt embarrassed that it didn't look as good as it should have. So I want to start with a little more detailed background on the property and to give you a little more orientation. The property is exactly where Mr. DiMarzo said it is. Zoning around it is what he said it is. We've got zoning maps in our material. We've got the soil maps in the material. One of the things I wanted to make sure everybody understands is how you relate the zoning and the uses in that area to the soils. I think it's very, very telling. So in this area, generally, you'll see from the Natural Resource Conservation Survey maps, you'll see that there's really two kinds of soils, two types in that area, 36, A and B, and that's that Des Camp soil. And then there's 58, which is the Ghazni rock outcrop. And you'll make your own assessment, obviously, from the material. But my assessment is if you look at the surrounding land uses, and there's an aerial photograph we've provided, you look at the zoning maps, and you look at the soil maps, you'll see a pattern. You'll see that there's areas where there's some small scale farming, not right around us, but mainly up in that corner by Reed Market. There's quite a bit small scale farming. The practices seem to follow the soils. So where there's a lot of 58 soil concentrated, like our property and the property to the east and the south, it's fallow, or it's zoned MUA 10 and developed with rural residential uses. There's two subdivisions to the southwest of us that are in that MUA 10. And if you look at the soil map, that's all 58 soil. So I think it's a real important point to kind of examine the uses in connection with the soils, because that dictates the use. It's not, in our estimation, the land that is comprised of soil that's not agricultural soil isn't used for agricultural purposes, and that kind of makes sense. So that's a little bit of the background. I wanted to tell you what the request is. The request is just to rezone it to MUA 10. There's no development. There's no plan for a cluster development. There's no proposal for a PUD. There's no proposal for any kind of subdivision, particularly any parcels less than 10 acres. And I'm going to get to that pretty fast because I think that's kind of a big issue from these new cases, and I think it might answer some of your questions to staff. In the first section of our response, we addressed 136.020 and whether the request conforms to the comprehensive plan. We focused on the relevant ones, and I think staff agreed with us that the ones we hit were the relevant ones. We looked at Chapter 2 of the 2010 plan. And the 2010 plan is the one that applies to our application because it's the one that was clearly in place when we provided our application. I think it's still in place because there's ongoing legal challenges. But in any event, Chapter 2 talks about resource lands. There is a policy for preserving agricultural land. We've explained that we've established through multiple sources, the maps that people rely upon, and a site-specific study that the land is not comprised predominantly of agricultural land. In fact, it's about 70% non-agricultural. So we think we're consistent with preserving agricultural land because it is an agricultural land. There's no need to preserve non-agricultural land under that policy. We've addressed the water policies in Chapter 2. There are no water resources on the site, but using irrigation and groundwater, irrigation particularly, any kind of irrigation on this soil is a waste of water because there's no holding capacity. Our site-specific study demonstrates that this soil has virtually no water holding capacity, and that's kind of critical for farming or for any kind of agricultural use. And then we go to chapter 3. That's kind of the big one. So here's my recitation of kind of the recent history. And Mr. Isbell's here. He's been involved in it more directly than I have, so he might clarify or correct a few of my things. But Central Oregon Land Watch had challenged the 2004 amendment in a case, Destiny Court, I believe it was, saying that the proposal in that case was inconsistent with policy 3.31, because that policy specifically said parcels in this zone are limited to 10 acres, and there's no exception. And so what Central Oregon Land Watch pointed out is that's inconsistent with the zoning code that allows cluster developments. And in that case, the original proposal by the applicant included a 14-unit cluster development. And LUBA agreed with Central Oregon Land Watch that that was an inconsistency, and they sent it back to the county to fix it. And I think that decision came out between the first and the second reading of the attempt to amend the comp plan. And so the county took it back, is my understanding, and they adopted some new policies in section or chapter 10, specifically 10.3.3 or 10.1.3, that said, notwithstanding the agricultural zoning or whatever, notwithstanding something, they were going to allow cluster developments on non-resource and resource land if it was consistent with the Administrative Rule 660-004-0040. That got challenged. And in this recent case that I just call Poaku Farm, because there's like a lot of Central Oregon Land Watch versus Deschutes County, so I try to find a name that will be distinguishable. So this recent case that came out April 14th, LUBA sent it back again to the county, saying that their new policy, 10.1.3, was also inconsistent. Well, not really, because it's inconsistent with the zoning. They confirmed that again. But the real problem, as I read it, was the new policy tried to apply that state reg to non-resource land, and LUBA concluded as a matter of law that the county couldn't use that regulation to create this consistency, because the regulation doesn't apply to non-resource land. And so if you rezone something to MUA 10 on the basis that it's not resource land, I think LUBA reasoned that you can't apply that administrative rule to authorize these cluster developments on non-resource land. To do that, the county's going to have to go back, as I understand it, and figure out under Goal 14 whether it can allow cluster developments on MUA 10, and then if so, how it will do that to pass muster. So that's my understanding of where we're at. How it impacts our case, though, I think it simplifies your analysis, because we're not quarreling with that case. Under the holding of that Poaku Farms case, as I read it, and I've talked to the county high up levels, I think they agree with me, is that at the current state of the law in Deschutes County, there isn't an avenue to create less than 10-acre parcels in an MUA zone. And so an application, a quasi-judicial application that doesn't ask for anything less than that, is not inconsistent with the law at this point, because the law only allows 10 acres, and that's all our application seeks, 10-acre parcels. So our view on this case is we're consistent with the old one, 3.31, which I think is in effect based on LUBA's remand, because it doesn't authorize anything less than 10, and we're not seeking anything less than 10. And so we think that case really helps you. And I think it helps you on the Goal 14 analysis. I'll get to this a little later. But in that Curry County, the DLC Curry County case, I read it to have created kind of a safe harbor under Goal 14. 10-acre parcels or greater are not urban. So you don't have to go through that detailed analysis under Schaefer if your parcels are limited to 10 acres. You're falling in that safe harbor. So that's the first prong of the county code, 18136. The second prong is B. Is it consistent with is the request to rezone consistent with the purpose of the proposed zone? And we've explained that in writing. I know we'll disagree with Central Oregon Land Watch on it, but we read that to say the zone should promote development that's consistent with the rural character. Again, because it's limited to 10-acre parcels, we think the rezoning to 10-acre parcels is very consistent with a rural character of the neighborhood. One of the purposes is to preserve agricultural land that's not suited for big commercial farming for small diversified farming. 10 MUA 10 parcels at 10 acres. We think and I think there's a lot of documents out there, even stuff that I think we received from Central Oregon Land Watch in the past, where these MUA 10 parcels are often used for non-profit motivated hobby farms. Somebody can justify doing farming at a small level because they enjoy it. And you'll read some of the material that Kyle submitted today about a farm. It's small scale, it's family. They just wanted to do that. They don't care if they make money or not. And they don't have to, because the real purpose of having that 10-acre parcel is they live there. It's their home, and then their kids and they work on the farm. So we think it's consistent with the purpose. The C is, will the rezoning presently serve the public best interest? And you've recently interpreted that provision to mean that if we meet the criteria, well, actually, that's the main one. I back up. I've got it wrong. The main question under DCC 18136 is whether the public interest is best served. And you previously found that if A, B, C, and D are met, you satisfy that. And that was disputed in the Bear Creek rezoning that we did. Central Oregon Land Watch appealed that decision, but they didn't challenge that part of your finding. So that part of your finding in the recent one out on Highway 20 in Bear Creek, that if you meet A, B, C, D, you meet the main provision that it's in the public best interest, that interpretation right now has been upheld, at least for now. And so we looked at I've covered A and B, get to C. Will the change presently serve the public's interest considering the availability and efficiency of public services? Well, there's really only one public service, purely public service. Well, maybe a couple. The one main one is roads, and the roads will presently serve it. We did the traffic study. The county traffic engineer, Tarek Rawlings, confirmed after some back and forth that our study was acceptable and showed that there was no problems with the roads. There would be fire and sheriff service would be the only other public services available, and they both got notice of this, and there were no comments that they couldn't serve the area. Water is quasi. It's a private Avion facility, and so there's a line in Dickey Road, and it serves the property for domestic uses only. We understand there's some limitations on the amount you can use based on the size of their facilities, but that's the water that would serve it. It's not public. There are no other public. There's no septic, or that's all septic. There's no public sewer. And so we think we've demonstrated C has been satisfied, and staff agrees. And then impacts on surrounding lands. Again, I'd go back to just look at that zoning map and the soil map. A lot of the area around this property is MUA 10 already, and it kind of corresponds with the 58 soil. And then if you look immediately west of our property, it's still EFU, but it's all 58 soil. Our submission on that is rezoning this property to MUA 10 isn't going to impact that, because that's the same bad soil. It's not going to be used for farming. We found no history of farming on it. It's just rocky soil, just like the majority of ours. And then there's a little EFU on the north, and we've addressed that. That owner apparently tried to make some farming work on it, but he's really bought it for speculation. He's trying to wait for it to come into the city. He doesn't live there. He has rented it in the past, but it hasn't been rented recently for farming. And so we've addressed that. We don't think 10-acre parcels on our property will impact any current or future farming on that property, given the purposes for which it was acquired and how it's being held. And then the other farming operations that I've identified are, in our opinion, pretty remote to have impact from MUA 10 development on our property, 10-acre parcels. The most you could put on is a dwelling on a 10-acre parcel. There's some farming up at the corner of Butler Market where it turns. That's 36 soil, but it's fairly far from our property. And our position is that, the uses that would go on an MUA 10-acre parcel are not going to have any appreciable negative impacts on any kind of farming activity on that property. The last county one is D, change in circumstance. Luba just confirmed in a case that I cited for you in our letter that site-specific soil map that shows what the soil actually consists of and whether it's suitable is a change in circumstance that you can consider. And so we believe, and I think you have in the past done that. So I think Lube has just kind of confirmed that how you and other hearings officers in the county have addressed this criterion, you're spot on. You're doing it right, and you're considering a better soil test as a change in circumstance. So now we get on to the state ones, and the main state issue, and I did the best I could responding to it in our supplemental memo based on my reading of the recent cases. You know, when we filed this almost a year ago in December, a lot of those cases hadn't really come down yet. So I've gone through the recent LUBA cases and kind of explained how our situation addresses what LUBA's concerned is. And how I kind of read the cases is, one is you have to, under Destiny Court, you have to look at any specific use that an opponent presents, right? If they say, these are uses that are customary in the county, and here's some evidence on how they can be conducted on this property, well, then we have to respond to that. We also have to explain how our property is not necessary to allow current or future farming on nearby or adjacent land. And so we've tried to explain that as best we can, but I didn't get Landwatch's opposition until about 10 minutes before the hearing. And that's fine. I mean, that's kind of, we expect that. But what I would ordinarily do is kind of spend more time today and before today preparing to respond to the opponent's positions under Destiny Court and some of these other cases like Last Ranch and Red Side. But I didn't have the benefit of their arguments. So we're going to do a little bit on that. And then I think we'll rely on the open record period that we want to submit a more formal response to Landwatch's arguments. But as far as soils go, the main test is it agricultural land? You know, that's the state regulations in 660. The question is it agricultural land? And there's, primarily two prongs. One is you look at the soils, and I think we've crossed that threshold. The soil tests and the soil maps are consistent. And when they're consistent, generally, we don't see much opposition to the technical issue. Is it agricultural soil based on the classification and the mapping? And I briefly read Landwatch's submission. I don't see a big disagreement on that. The big disagreement is what we see in the recent cases, though, and that is, even if it's not class 6 or better soil, is it still suitable considering the factors in the administrative rules? Soil fertility, grazing, suitability for farm practices, technology, climate, all those factors. And like I said, we've done the best we could without having specific comments to respond to, explaining how it's not suitable. And we've done a little bit more. And at this point, I kind of would like to have our consultant, Greg Jacobs, testify. He's a consultant that has been on the farm or the property. He's been around, looked at some of the other properties that are both used in agricultural and not. He's kind of done his assessment of suitability, and I'd like him to, we'll probably respond more in writing during the open record period, but I'd like you to, when you get those comments in writing, I'd like you to know who they're coming from, because he's a very impressive person who knows this stuff and actually does it. So if we can switch places here with Cody, you can move down there, Greg. You got to get up. But you can use it.
Good afternoon.
Sir, if you could give the first and last name, spell the first and last name and give your address, I'd appreciate it.
Yeah, it's Greg Jacobs, Jacobs, and I'm at 65745 Old Bend Redmond Highway.
Mr. Kobach, if you want to ask questions, you may. If not, he's certainly willing. I'm willing to allow him to narrate.
I'm going to just introduce topics and then you got that one.
Yeah,
let's just Mr. Jacobs answer those. So, Mr. Jacobs, first of all, let's tell the hearings officer who you are, what your experience is, trying to relate it to farming as much as you can.
Sure. I grew up in the Willamette Valley on a family farm and did some military service and a professional career. And then I went back to farming in around about a decade ago out in Tumalo.
Okay, tell them about the farming operations that you have now. What do you do on your farm and what kind of activities do you engage in?
Yep, currently we raise alpaca and Icelandic sheep We have done, we have a better soil, better water, and a better and more open fields. So we have some, I guess you would call it commercial abilities out there. We've done potatoes, we've done hay, and we subleased the fields for CBD hemp back in the day. However long ago that was profitable.
All right, so now tell the hearings officer kind of what you perceived your mission was for this case, and then what activities did you do to prepare for this testimony today?
Yeah, I didn't really know what to expect, so I think the first thing I asked to do was go out and do a site visit because that tells you a lot once you see the dirt. So I went out and I studied the packet that has been back and forth, and then I went out and did a site visit on May 1st. Dug some of my own test holes and just did an overall assessment of dirt and feasibility of farming out there.
And do you feel qualified to give testimony on whether a specific property in Deschutes County is suitable for farming, considering the factors that you read about in the material I gave you?
I do.
Okay. And what is your opinion as to the suitability for farm activities as that's defined in our code and statutes for the property at Dickey Road?
Nearly impossible. As I say, this is America and we can do anything we want, but feasibility and the cost involved and what it would take to bring this up to operation would absolutely never make sense in the life of the farm or the life of the farmer. It would just be too expensive.
So one of the things that the cases I gave you talked about is whether a reasonable farmer would be motivated to engage in farming for a profit.
Yeah.
What are your thoughts on that?
I don't know how it could be done on this property for profit. Again, there's all the prep work that goes into it, but as is right now with the amount of soil, rocks, and lack of water, I do not see any profitability avenue out there.
And so there is some land out there, a pocket or two of soil that's not 58C. Did you look at whether it'd be suitable for farming if you just use that limited area? Again, applying that reasonable farmer motivated for a profit test?
I did. I took several pictures. The surface rocks are between 28 and 36 inches that you would have to pick off the surface. But the more important part is the substrate rock is down less than 4 inches. And, again, with tractor implements and everything you would need to work the soil, you need at least 8 to 12 inches of soil that is rock free without destroying your equipment. So I don't see how it's feasible, even in what we would call the good soil out there. I don't see it feasible.
Now, can you talk at all about some of the smaller operations that you observed in that area and other areas, and whether those are activities that you perceive to be engaged in for the primary motive of making a profit?
Yeah, I don't know that they're designed to make a profit. I think, much like you said, it's a lifestyle that people are after. And to me, all of those farms are in they're smaller and more manageable. And smaller and more manageable does a couple of different things for you. You can concentrate your efforts. You can concentrate, the money that you're putting into that, or the resources that you're putting into it, and get better yield on a family-based, garden plot or, small animal husbandry that's designed for family or family and friends, not designed for profit or commercial use.
And lastly, we talked once at my office about this notion of whether or not you could convert this 58 Gosney rock soil into better soil through an amendment process. Do you have an opinion on how feasible that would be?
Well, again, amending soil is a practice, but on the smaller farms, what they're doing to amend their soil is, number one, they're picking a smaller area that doesn't have the rock substrate, and then they are loading in either the wood chips or manure or whatever type of topsoil on top of it to get a very, very small area. And I mean 30 by 60 as their grow area. If you were trying to duplicate that on 50 some odd acres, again, you'd be bankrupt before you even grew the first crop.
And does that have a lot to do with the amount of rock on a property?
It has to do with a lot of rock and what the rocket does to your equipment. I mean, people don't realize, it's all about the tractor that you are using on this thing. And again, on this property with these outcrops, you could not maneuver a commercial tractor in the area because there are too many large chunks of it's like having bollards at a bank. You'd have to go around each one of them. On a commercial grade tractor, you don't want to have to back up. And I don't see any areas around here. You've seen tractors in a field. They're doing one large swoop around it. There's nothing in this area that could do that.
So, Hearings Officer Frank, if you have any questions of Mr. Jacobs, he's going to be here. Otherwise, I'm going to have him sit down. I'm going to finish up my presentation and then let our colleagues from Landwatch talk.
I'm going to hold off on my questions depending on what Landwatch raises. My questions are going to relate to one of the comments that you made regarding the list of possible uses, the Destiny Court decision, and which ones you have to address, because Mr. Jacobs may be relevant to addressing a specific use not raised by him in this testimony. So just letting you know. If this were a court, Mr. Jacobs, I'd say you're not excused. Basically, you can't go anywhere. I have no authority to say that, but that's what I'm telling you.
Very good.
All right.
Okay. With that, I'll just wrap it up. The only thing left I had to talk about was the code also requires in a rezone and an amendment to the comp plan that we address the statewide goals. Statewide goal 1 is relevant, and we're here in the process, so we feel that the county process is inconsistent with the goal 1 of participation. Goal 3, we've addressed that through the soils. It's not goal 3 resource in our opinion. We presented compelling evidence to that, I think. And then statewide goal 4 is not applicable. It's forest land. 5, there are no mapped or inventoried resources, unlike some of the other ones we've done where we've had the scenic corridor. That's not on this property. The only other one that I think merits any real discussion is goal 14, and it's kind of limited again, because if you accept my position, and I think Luba's ruling in that Palaco Farms case, because the law now only allows 10-acre parcels in MUA 10, and Curry County said, 10-acre parcels are basically presumed to be rural density. We don't think there's really any detailed analysis required under goal 14. That safe harbor seems to say that's a rural use. So we don't need to spend a lot of time on that. If it comes up during opponent's testimony, obviously we'll address it during the open record period as necessary. So unless you have questions of me, we're concluding our presentation in chief.
Okay, thank you, sir. Is there anyone else who wishes to testify in support of the application?
Seeing none.
All righty. Thank you, Mr. DeMarzo. Anyone in opposition?
We do have Central Oregon Landwatch.
Good afternoon, Hearings Officer Frank. Can you hear me?
I can hear you just fine. Just who are you? I know who you are, but for the record, who are you? And basically, where's your mail come?
Of course. For the record, my name is Rory Isbell. I'm a staff attorney and Rural Lands Program Director with Central Oregon Landwatch. Our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon 97703. I do want to thank you for being here for this hearing and accepting public testimony today. I have emailed and I just handed a paper copy of some written comments from Landwatch to staff, to Dan, just as I walked up to the microphone here. Also, as you heard from the applicant, handed a copy of those comments to the applicant's attorney as well. So the written comments that we've submitted, sort of a tag team effort, but my colleague at Landwatch, Robin Hayakawa, was primary author on those. He's out of town on vacation today, so in a sense, I'm filling in. But I will let the comments speak for themselves, but I will take this opportunity. Again, thank you to talk through a few issues. The first that's already had a good bit of discussion today is the county comprehensive plan, specifically policy 3.3.1, how it relates to goal 14 and the MUA zone. So that policy, I believe, as you know, mandates that the minimum parcel size for new residential parcels shall be 10 acres, except for one specific zone in the county, the West Side Transit Zone. Relatedly, the plan at section 3.3 states that Deschutes County requires a 10-acre minimum lot size for new residential lots in order to protect the rural quality of life and its resources. And of course, the MUA zone requested by today's applicant for the subject property allows significantly smaller parcels. It allows parcels really with no minimum lot size in a planned development. And because this property is within 1 mile of an urban growth boundary, it allows a 5-acre equivalent density. So density equivalent to 1 dwelling per 5 acres. So significantly smaller than 10-acre minimum lot size. In the Destiny Court case, the applicant there also sought to rezone agricultural land to the county's MUA zone. And LUBA found that the county did not address in its decision the conflict between the MUA zone and Comprehensive Plan Policy 3.3.1. That same conflict is present in the current application. I did hear the applicant sound like try to distinguish that case by noting that at one point the applicant in the Destiny Court case had included some type of conceptual plan for a subdivision. But you know, it's noted in LUBA's decision in that case, that applicant withdrew that somewhat vague conceptual plan for a future subdivision. And yet LUBA still found that the county's decision approving the rezone to MUA had an apparent conflict with the county's comprehensive plan because the MUA zone allows much smaller lots than 10 acres. And more recently, another LUBA decision that's already been discussed today, it was Landwatch's challenge to the updated Deschutes County comprehensive plan. LUBA remanded the plan there on the grounds that it, just like the current county comprehensive plan, the new one contains policies allowing the MUA zone to be applied to non-resource lands or lands that are rezoned out of agriculture without taking a goal exception. And LUBA found that the county may not rely on standards regulating development in its rural residential exception areas, so areas where goal exceptions have been taken. The county may not rely on those development standards to find compliance with Goal 14. LUBA observed that the development allowed in the MUA zone is more intense than Goal 14, than what Goal 14 requires in order to maintain land as rural land under Goal 14. Those same faults, I'll call them, that LUBA identified in the county's comprehensive plan policies that allow the MUA zone to be applied to non-resource land are still relevant here. And I think we got clarification on that point from LUBA in the recent comprehensive plan case that the applicant refers to as the Poeku Farms case, just so we're clear which ones we're talking about. So we do believe that this current application cannot be approved because it would conflict with Deschutes County Comprehensive Plan Policy 3.3.1. I do want to talk a little bit about Goal 3 and how it applies to this application, starting with what I call the necessary standard, which is the standard at OAR 660-033-0020, subpart 1AC. This is one of the prongs of the state's definition of agricultural land. It states that land is agricultural land when it is necessary to permit farm practices to be undertaken on adjacent or nearby lands. Our written comments identify several nearby and adjacent properties engaged in farm practices, and we distinguish the rule specifically uses the phrase farm practices, not farm use. So it's very forward-looking. It's not concerned with the statutory definition of farm use that does allow a county to, take some minor consideration of profitability. The relevant rule here discusses farm practices to be undertaken, so today or in the future. We believe that this subject property with its EFU zoning is part of a large block of agricultural land and that the EFU zoning on this property is necessary to maintain the opportunity for a wide array of farm practices to be undertaken in this large block of agricultural land today or in the future. The lack of conflicts that EFU zoning provides are what makes a large block of agricultural land successful, in line with the state's agricultural land use policy at ORS 215243. Jumping to another prong of the state's definition of agricultural land, the suitability prong at OAR 660-033-00201AB. This is where the 7 factors are listed that must be considered to determine whether property is suitable for farm use. As a bit of an initial or threshold matter, which we do discuss in the written comments, in our understanding, this application places too much emphasis on very conjectural notions of profitability. And doing so is directly counter to LUBA case law, both case law from the late 2000s, so 15 or 20 years ago, and also much more recently in the Destiny Court case, where LUBA said that profitability is, quote, a relatively minor consideration and one with a significant potential to distract the decision maker from those 7 factors listed in the 1AB prong of the agricultural lands definition. So considering those 7 factors, and I will point to our written comments that discusses each of those 7 factors, we believe the subject property is suitable for the many farm uses that exist both on nearby and adjacent lands and in other areas throughout Deschutes County. Just as one example to call your attention to now, an adjacent property is raising pigs, sheep, and cattle, and there's no reason the subject property could not be used to do the same, given the customary farm practices that go into preparing a property for farm use in Deschutes County. I'm mostly going to leave it there. There's a couple other issues discussed in our comments, but just to sort of conclude, Landwatch's position is that this property is accurately designated agriculture in the county's comprehensive plan and zoned for exclusive farm use, and that exceptions to Goal 3 and 14 would be required in order to rezone this property to the county's MUA zone. And of course, the purpose of that MUA zone, which is explored in the recent case law we're discussing, Destiny Court and the Poheku Farms decision, the purpose of the MUA zone is to regulate land uses in exception areas, so areas where goal exceptions have been taken. The subject property is not one of those. So we believe an exception to Goal 14 would be required in order to apply the MUA zone to this property. That's all I had for oral comments today. If you have any questions for me, I'm happy to stick around.
Just initially, just one, and that is that the MUA 10 zone at Destiny Court included the cluster and the 1 mile, I call them exceptions, bad choice of word when we're talking about goals and guidelines. But it included those provisions that allowed for density less than 10 acres. I asked staff, I asked Mr. Kovac, and so I'm going to ask you the same question. What MUA 10 provision applies in this case? Because your testimony was that similar to Destiny Court, there was the cluster and the 1 mile, I think it is, whatever the mileage is, the other provision allows greater density. And so what I'm trying to figure out, and I have, just so you know, I have in front of me a current copy that I took off yesterday when I was doing my review, version of the 1832 multiple use agricultural zone MUA. And I go to 040, and you can certainly educate me, and I'm open to that. Certainly, Destiny Court decision of LUBA educated me, and that is all a result of your efforts. And I don't do anything other than say, hey, if I can do better, I'll do better. And I learned from that case, at least that decision. But I'm looking at it, and there is an ordinance in 7/1/25. There's an ordinance on 3/28/25. those are the most recent ones. My recollection is Destiny Court, the one that I decided at the hearing level, initial hearing level, applied the cluster and the 1 mile, the version that had those in it. And my reading of Destiny Court, and correct me if I'm wrong, my reading of the conflict between 3.31 in the comp plan and the version of the MUA 10 that got sent back was that it conflicted because it added provisions that allowed lesser or greater density than 1 per 10 acres. So what version am I supposed to apply in this case from your perspective?
Yeah, I believe I understand your question, Hearings Officer Frank. And as you referenced, I believe last summer the county did amend the zoning code. My understanding, and I've heard you ask this question to staff. It sounds like they're planning to follow up. I would look to their response to inform the answer to this question as well. My understanding is the county didn't change any allowed uses in the MUA zone. What they did is they restructured the code to move some of the standards that govern those allowed uses to different sections. So I would point you towards, and this is in our written comments on page 3 that I know you will see soon, DCC section 18.116.400 A3 is where the county zoning code allows for cluster and plan developments in the MUA zone, and allows them to be an equivalent density of let's see, a 5 acre minimum lot area equivalent density when within 1 mile of an acknowledged urban growth boundary. So that's DCC 18.116.400 A3. So I think, the bigger question that I hear you asking is has the county's MUA zone changed since the Destiny Court decision that would change the outcome in say the current application compared to the outcome in Destiny Court? I believe no, it has not, because the county still allows those same uses, those cluster and plan developments that allow very small minimum lot sizes and that density bonus, which is what I call it. You call it an exception, I'll call it a density bonus.
Whatever.
That allows higher density the closer a property is to the urban growth boundary in the MUA and RR zone. Of course, we're talking just about the MUA zone today. Does that hopefully
It
help?
does. Just for point of clarification, would you, and I just want to make sure I've got the citation correct. Give it, it's what is the citation? 18 what?
DCC 18.116.400 subpart A3.
Thank you. That's helpful. Okay. All right, I'm going to wait until I see your written submission or the Central Oregon Watch written submission. And just as the other point of a clarification, because in the Destiny Court, which is near and dear to my heart, because that's how you learn to get better. In that case, LUBA went out of its way to suggest that my ruling was too narrow because I didn't look at the animal husbandry and horses and that issue or those issues, those uses. And so what I got from your testimony, I wanted to be as clear as possible, that there is, let's see, what did it say? Raising pigs, sheep, and cattle. So I'm substituting raising pigs, sheep, and cattle for animal husbandry and horse, whatever the other one was. Is that the additional use that you're asking me to look at to see whether or not? Because obviously, I don't want to have findings that don't adequately address what LUBA suggested that we need to address.
Sure. And, I would really point to our written comments at page 9 through 14. We do list a handful of other farm uses that,
Okay.
given what we've learned about the area and nearby and adjacent properties, seem to be suitable on the subject property as well.
Okay, I wasn't trying to be presumptuous and pin you down. I haven't seen the written information, and if you could clarify, and I could, from my side of the screen, I'm always looking to simplify. And if I have straightforward, simple issues, then I have the ability to render findings that include or don't include substantial evidence and relate it properly to those findings. Just as an editorial comment, because I can't pass by because I don't see you very often, or Central Oregon Land Watch. I will tell you, I am, having read a number of these cases that have come out in the last year or so. When you look at the definition of farm use and you see the way that language is structured, I'm not saying where my political leanings are because they have nothing to do with it. But if you use Justice Scalia, Justice Scalia's book on trying to interpret what legislative aspect or legislative language means, and even looking at 174, whatever it is in the ORS, that says the language, if it's clear, it's clear. And I have to admit to you that it's my opinion that the state we're in now of trying to answer questions like are presented in this case based on LUBA decisions, and in part some of the Court of Appeal decisions, but mostly LUBA decisions, is like walking into a conundrum. I mean, it's like walking into something that doesn't make really very much sense. The language for farm use, despite your testimony and despite what Luba says, that profitability distracts from the seven figures or seven factors, I find that almost offensive. It suggests to me that I can't look at seven factors and analyze seven factors, but I also can't look at profitability. It seems to me if you look at the plain, clear language of the definition of farm use, what Lube has created, in my opinion, is a morass and makes my job harder. And yes, maybe it keeps you busier and gives you some opportunities, but I don't think it ultimately addresses what is really important here. And I don't dispute in any way, shape, or form. I don't even question the slightest your motivations and your policies and your goals of protecting farmland. I'd be a hypocrite if I said that was wrong. That is absolutely correct. But the situation we're in now, and I think got worse over the last year, with the Luba decisions, is problematic. And it seems to me is that Central Oregon Land Watch's primary purpose ought to be through the legislative. My predecessor here, Ken Helm, worked for me when I was city of Portland as a hearings officer. Is an important guy, and it seems to me people like him need to figure this out and get this cleaned up, because I think it strongly. I don't disagree with Mr. Kovac and his clients' goals. It just seems to me that I am a lawyer who likes the law. And as a person who respects and likes the law, it would be nice if we had something that we could all work with, where Mr. Kovac and yourself would say, "Hey, we can disagree on this issue because there's an interpretive issue," but the way we're stuck in this mess right now, it seems to me really sad. So anyway. Sorry, I apologize for an editorial comment. Probably inappropriate for the hearings officer to do that, but I really respect what you're doing. But I also respect Mr. Kovac and his clients' efforts to try to do what they believe is correct. And it's kind of a disaster right now. So I will do my best in this decision. I think I have another one coming up in some way, shape, or form in the end of June. I'll probably see you again. Or maybe Mr. Hayakawa. But it seems to me that coming to some agreement as to what some of this stuff means would benefit all parties. So I appreciate you being here. I appreciate your testimony, appreciate your organization, and I'll do my best to try to follow what I believe is the law. Thank you.
Yeah, thank you. Appreciate your thoughts on the matter. I'll withhold my own, but I do appreciate you taking the time to edit the witness. Thank you, Hearings Officer
Yeah.
Frank.
Yeah, well, mine were inappropriate. Yours probably would be too. So
Yeah.
whatever. We'll do our best. All right, Mr. Kobach, or is there anyone else in opposition?
No, sir.
Is there anybody neutral?
There is not.
Mr. Kobach, you're back up.
Thank you, Mr. Hearings Officer. Again, Chris Kobach for the applicant. I'll make my own comments. I don't think there were any errors made in Destiny Court. I think Destiny Court illustrates one of the most interesting things that keeps us doing what we're doing as land use lawyers and practitioners and planners. The law is evolving, just like it does everywhere. And before Destiny Court, every hearings officer in Deschutes County that I remember analyzed farm use the same way. We looked at grazing and livestock because that's what everybody in Deschutes County uses property for mostly. And so LUBA just gave us another question. and so we're dealing with it. And I agree that we could all benefit from a little bit more pointed and consistent guidance from LUBA on what is farm use and where does profitability factor into it and where does profitability cross the line. Where do all the other factors weigh in as far as priority? Are some more important than others? I do note that I think LUBA has done a little bit to give us somewhat of a clearly articulated test in the first Red Side case, and I quoted it. And the question is, would a reasonable farmer motivated by profit for the primary purpose of making a profit attempt to engage in one of those activities listed in the statute? So you can't, and I think LUBA got there by agreeing with the Court of Appeals decision that because profitability is intrinsic in the definition of farm use, it's always going to play a role. But I agree with you. If we had a little bit more judicial guidance on what role exactly that is, we could maybe narrow some of our fights or at least make them a little more efficient. But I agree with you too. We'll do the best we can. So on this conflict, that's one of the things I kind of disagree the most strongly with Central Oregon Land Watch, because I agree that DCC 18116 still has these provisions in the code. And they've always been in the code. So the code is inconsistent with the policy. But what I'm confused by is in these recent cases, including the one that I mispronounced, Poaku. How do you pronounce it?
Your guess is as good as
Oh, you were just guessing too. Okay. Well, in that case, Central Oregon Land Watch argued that the zoning code isn't valid because a zoning code that conflicts with the comprehensive plan isn't valid under the Baker versus the City of Milwaukee case, Oregon Supreme Court case. And so I accept that argument. And so my point is, if the law is that the comprehensive plan controls, and you come in with a quasi-judicial application for rezoning to MUA 10 without a specific request for something not allowed in the policy, you're not creating an inconsistency between your application and the policy. And because the code provisions are not enforceable under the Milwaukee case, there's no conflict there either. You just can't do it right now. Now, I also don't disagree that Central Oregon Land Watch has every legal right and ability to go continue their facial attack on the county's plan, because that's where this is going to get cleared up in a better way. My point is, when you can't traverse that or take that facial attack and apply it to a specific requirement unless you can identify an inconsistency between the application and the policy, and you can't. And I think that LUBA in that recent case, and I quoted it, they really answered the question for us. This is after Destiny Court. It's after the other cases, it was in this April case that just came out. Luba distinguished the red side case. Because the county was arguing in this facial challenge that, hey, red side stands for the proposition that if we're allowing uses that are not more intense than allowed under the state regulations, then we're still okay. And they relied on red side. And on page 5 of my letter, I quoted, and this is right from that Poaku case, Luba distinguished red side is on the grounds that it involved a quasi-judicial designation of non-resource land along with a PAPA, post-acknowledgement plan amendment, to allow 10-acre parcels, but did not involve either cluster or planned unit development or the application of OAR 660-004-0040. So I read Luba to have said just in April that if in a quasi-judicial application, if you're not asking for something inconsistent with that policy, you're not creating a conflict. And I think that's the last statement from Luba. I think it's as clear as Luba's going to get. So that's really all I wanted to clarify a little bit. I will address some of the other stuff in the written argument. I appreciate the argument that Landwatch has made about the necessary standard. I think they ignore the term necessary in a lot of their analysis, and we'll inform you on our position on how that impacts the analysis. Our suitability. I think that comment that our suitability was based on conjecture was probably written before Landwatch heard from our expert, because our suitability, lack of suitability analysis was based upon something that Landwatch will never be able to give you, ever. Somebody that walked the ground, dug soil samples, has actually tried to farm land, and knows what they're talking about as far on specifics on the ground. The first thing I told Mr. Jacobs when I asked him if he was willing to do this engagement, I said, you will be on that property. I will not put somebody up on to testify on this issue unless you have the credibility that comes from being on that land, digging that soil, evaluating on a level. Get on your knees. And so we have more than conjecture, and we'll elaborate on that in our written comments. Thank you.
One more question, and then I'm done. I didn't look up before this hearing the 116, whatever I'd have to look at it, but whatever the site that Mr. Isbell gave me that still allows the cluster and allows the 1 mile provision. Just as a hypothetical, that's not hypothetical, what would prohibit or restrict your client or any successive owner of the property, if I approve this and became final, from later making an application under those provisions that allow for the cluster or the 1 mile provision?
Luba's holdings. They're not allowed.
Okay. So you're saying basically Baker versus City of Milwaukee.
Yeah, candidly, somebody could come in, and you've seen it, I'm sure in your career, I've seen it, where applicants come in with an application and you determine that it's not consistent with the law and you can't approve it. So my view is that's the quasi-judicial branch. If somebody came in with a future application and said, I want to cluster this property, I think under the current law, the staff would have to recommend denial, and the hearings officer would have to agree with that, because cluster development right now has been found by Luba to be inconsistent with the policy and the policy controls over the zoning. That's why at this point in time, we're not asking for anything inconsistent. And so that's where I'm trying to I think that's the distinction Luba made in the red side case. In that case, there was nothing other than, hey, we want to rezone this. And because Luba had already held that only 10-acre parcels can be created because the policy controls, they agreed that red side did not create a conflict. Now, the conflict still exists, as I said, but it's on this facial challenge, and that'll work its way out, and the county's going to do whatever it's going to do. But I don't expect that you'll see many people going in for cluster developments on MUA 10 land now because they'd be wasting money. I think everybody's gonna have to wait until the county does what it does. And if clusters are authorized and that's upheld after another challenge, well, then applicants will have some guidance. But it kind of goes back to this farm use thing. We're kind of gonna have to wait to get some better guidance from the law, from the review bodies. That's my opinion.
Okay. No, appreciate it. And you
right.
said it. I just wanted to make sure I was clear. And
Yeah,
I am
yeah.
now clear
I'm just not reading
on
the law the way I read the law, and I'm obligated to candidly tell you how I read the law. I think that the LUBA has held that 10-acre parcels are the minimum right now.
Okay. Thank you so much. All right. Anything else on behalf of the applicant? I'm assuming not, since Mr. Kobach has left.
Oh, no, I guess we should just talk about the open record period.
Okay.
Unless you have to do something formal before we do that.
I'm gonna just stay there then, would you please? Because I'm obligated under the procedures to have staff give any final comments that staff may have. So, Mr. DiMarzo, floor is yours.
Thank you. No further comments from staff.
Any suggestions? Well, I'm going to go to Mr. Kobach. Mr. Kobach, suggested open record period.
Yeah, I just conferred with Mr. Isbell, and we both agree that a typical 777 period would be appropriate.
Okay. So I'm going to go back to Mr. DiMarzo. Mr. DiMarzo will give us some dates and give us some instructions regarding the open record period. But I find that a request was made for an open record, and staff are the applicant and Central Oregon Land Watch have agreed at a 777. So, Mr. DiMarzo, the floor is yours.
Thank you. So for the open record period, please keep in mind that all submittals should be addressed to me. Email submittals, please utilize my county email, dan.demarzo@deschutes.org. It's important to note that the county does not retrieve information from a website link or cloud storage device. It's your responsibility to submit all evidence and testimony that you want the hearings officer to consider in an acceptable manner. Electronic submittals must be received by the county server by 4 p.m. Please do not wait until the final minute to submit your evidence. It does sound like we're in agreement for a 777 open record period. The dates for that would be the first 7-day open record period will end Thursday, May 14th at 4 p.m. The second 7 rebuttal period will end Thursday, May 21st at 4 p.m. And then finally, the applicant's final argument will end Thursday, May 28th at 4 p.m.
Thank you, sir. Just as a quick reminder, and it's probably overkill considering the qualifications of Mr. Kobach and Mr. Isbell and his staff. But the first open record period, anyone, whether they're here or not, has a right to submit. Second open record period is rebuttal, and I would like to hold you, anyone submitting during that period is rebutting what has already come in. It's rebutting. That means not new evidence during the second period, and the last 7-day period is the applicant's final argument, and the applicant is the only one who has the right to submit a final argument in that. Does that make sense to you, Mr. Kobach?
Does, thank you.
Mr. DiMarzo, does that make sense?
Yes.
Okay, and Mr. Isbell, just raise your hand if it makes sense to you.
Yes, it does.
Okay, well, I even heard that. All right. With that, then, I appreciate all the testimony. My editorial comment had two purposes. Number one is it made me feel better, simply because it seems to me this area has become so complex that I think it could be simpler. But it had that purpose, but it also had the purpose of trying to prompt both Mr. Isbell and Mr. Kobach to do whatever they can to clarify any of the issues that have been raised in cases, whether or not they be the recent Jefferson County or Destiny Court or the Poharka case or even the last ranch. Issues that are at least directly or tangentially related to this case come up in those cases. And so the more you can clarify those, the more likely it is that I'll actually understand. Having me understand may seem like it's not such a big deal, that it shouldn't be necessary for me to understand, but I can't draft a meaningful decision in this case or a recommendation in this case without your help. And from that perspective, I'm really asking in this one. This obviously isn't the first one that's going to occur. It's not the last one that's going to occur. And the more we can do to flush out these issues based on Mr. Kobach's comment and Mr. Isbell's comments, the more we can do that and evolve this process as quickly as possible, I think we're all going to stand in a better position. So with that, then I'm going to close the hearing. Thank you both for your testimony. Thank you, Mr. DiMarzo. We'll close the hearing at this time.